Toronto commercial arbitrator and litigator Earl Cherniak says the discussion paper towards a new Uniform International Commercial Arbitration Report is out for consultation across the country. Well, Earl, let's start with some background. Why is a new uniform Canadian arbitration needed?
Well, let me give you some background. In 1985, a body called the United Nations Commission on International Trade Law, UNCITRAL as it's known in the profession, came up with a model law for arbitration for the world, really. And it was adopted in a number of countries, including Canada, but interestingly not the United Kingdom or most of the United States. In Canada, it has to be adopted and was adopted by individual provinces and Canada. But over those years, it's anything but uniform. It's close to becoming uniform, but it's not. As well, lots happened in the almost 30 years since 1985, and indeed in 2006 there were a number of amendments that were adopted by UNCITRAL, which are themselves out for consideration by all the countries that have adopted the model law. So it was considered that in Canada there's a body called the Uniform Law Conference of Canada that considers rationalization of a variety of laws, including commercial laws, all across Canada. That body has taken up the task of thinking about the 2006 amendments and updating and making uniform the model law and the International Commercial Arbitrations Act all across the country. So a working group was established. It came up with a detailed discussion paper early this year. They put that discussion paper out for consideration by a variety of interested groups, including various arbitration organizations and individual arbitrators and persons knowledgeable in the field. They will all report back to the working group. The working group will come up with a detailed report which will be considered by the Uniform Law Conference at its meeting in August. So that's where we are at the moment.
Of the 5 draft policy recommendations, does one stand out as most crucial?
Well, I think the most, I'm not sure crucial is the right word, but certainly there are 2 or 3 very controversial and very important ones. One of the most important is the question of whether the power of international arbitration, commercial arbitration panels should be given the power to make ex parte orders, that is, orders without notice to the party that's going to be affected, usually because of some kind of emergency. Whether that's necessary in Canada, whether it's a good idea to expand the limited powers that they already have, that's an important issue. Another one is the question of limitation periods, because the limitation periods are anything but uniform all across the country, and the question is whether they should be made uniform for those cases that are those arbitration cases that are international in scope. And then there's also the question of enforcement in Canada. There's a convention, a treaty that Canada has subscribed to since the 1950s called the New York Convention, which makes foreign arbitration awards enforceable in Canada much more easily than litigation court awards from foreign jurisdictions. It doesn't apply to internally to international commercial arbitration awards under the model law. One of the questions is, should it? So there's a variety of other issues that are also important, but those are among the most important.
Well, interesting information. Thank you very much.